Well, good afternoon and welcome to another episode of Ask Two Lawyers. You're here with Keith Davidson
I'm Stewart Albertson.
and it's nice to be here again with everybody. We have a number of updates about cases that we have been following recently in the news. And then we also have gotten quite a few questions, legal questions, both in the area that we do, trust and will litigation, but we've also gotten some questions about some of the cases that we've been covering, the Girardi case, the Vanderpump Rule case. And I think that it just kind of prompts other questions in people's mind when we talk about these cases, which is always fun and interesting to hear about. But let's start off by doing an update on the Vanderpump Rules. And there hasn't been a ton going on in terms of the legal aspects of it, although there is a small update on the appellate side. But if we could have producer Eric come in. I'm sorry, I'm not used to that title.
Yeah.
I don't walk around all day calling you producer.
Yeah.
So, but if you could kind of set the stage for us exactly what happened recently with the I think it was Rachel Levis.
Yeah. So we've seen some people kind of digging around at some of the court documents online, people who are interested in this case. And, someone found something they had a question on. They said, help me understand this. And they pointed to this appeal that happened last week. And it says notice of default issued. And someone says, does this mean that Ariana's lawyers have failed to pay the fee for the appeal? I'd spoken to one of our coworkers, Christy, who was on with us a couple of weeks ago. And she was talking about how, sometimes, the appellant doesn't fix the default within a given time. The court can dismiss the appeal, meaning the case won't move forward. But in this case, the lawyers will probably pay the fees and things will move on. But could you guys talk about that a little bit further?
It may not just be the fees either, but you're referring to Christy. That's Christy Eisenbray, our paralegal, who used to be a paralegal at the Court of Appeals. And remember that both Rachel and Ariana, they both appealed. There's cross appeals. So I'm not quite sure who got the notice of default. But there's a number of things you have to do when you appeal. You have to pay the fee. You got to designate the record. You got to get the transcript. There's all sorts of things that you have to do. But how do defaults work in appellate court, Stewart?
Well, since I've handled 4 appeals in my whole
Right.
career, I want to say, first of all, I think the staff and the judges at the Court of Appeal are some of the finest that you ever will cross. And I'm not just saying that to say what I'm about to say. I think that they're the cream of the crop. And we're so lucky to have Chrissy Eisenbray with us. She used to be at the Court of Appeal, and she's fantastic as a paralegal, and we love her, and she's awesome. So I've heard that many appellate lawyers use the defaults or notices from the Court of Appeal as kind of reminders that they
Right.
need to do something. And so it may mean that they're abandoning the appeal, but more than likely it means that they just have given a warning shot by the Court of Appeal that, hey, we need to see some action here. You've got some things you have to do. The appellate court system is very much a checklist driven type of practice where you have to do certain things at certain times, but there's a lot of grace, it appears, in due dates where you can get an extension after extension after extension. And even if you don't make that extension, sometimes it's kind of like, hey, we're going to dismiss this if you don't do something. So I think that's probably what's going on here, but I don't know. I haven't looked into it any further than that.
Yeah, you always seem to get multiple chances at the appellate court, which is fine. I mean, that's, in the interest of justice. And then it's very technical. So there's all sorts of little technicalities you have to do. And even when you submit the brief, like it has to be in a certain format and there has to be certain information. And that's kind of true at the trial court level, but not to the extent that it is at the appellate court level where they really, stick to those rules. So, yeah, I would agree. I would anticipate that it's just a reminder on the record, but we'll keep an eye on it and we'll see where it goes. What I'm really interested in is seeing an appellate brief. And, we're probably a few months away from actually seeing an appellate brief being filed in that case. But it'll be very interesting to see what the arguments are when that goes up to appeal. And a lot of times, and this is true of us too, when you move from the trial court to the appellate court, you'll bring in somebody who's a certified specialist in handling appeals. And because they understand that world, they understand all the technicalities, but also they understand the arguments, because well, depending on the type of issue, you don't necessarily get to just retry it again. There are some instances where they call it de novo review, where they'll see it from the beginning. But You really do need a specialist, I think, when it goes up for most appeals.
I've got kind of a funny story on this. We were going against a very, very big law firm in California who will remain nameless.
Right.
And the attorney on the other side would call me up, and he literally would beat his chest and scream and yell. And he would send incendiary emails and tell us how he was going to bury us and pound us into the sand and crush us, and how we didn't threaten him, and how he's not scared of us, and just on and on. I mean, it was kind of humorous to get his emails.
Yeah.
And so we were going up on a motion in front of San Francisco in a court up there, and we ultimately lost that. So I guess it's true that he did crush us, but he didn't crush us, because what he did is he went and found the very finest appellate lawyer in his very big firm, and she was one of the finest appellate lawyers that I've ever come across. And she did a darn good job in that case, but he didn't do it. And the reason he didn't, he's smart. He's smart that he didn't do it, because it is a different world to be at the Court of Appeal and to follow all those rules, to be comfortable in front of the justices in that setting. It's much more formal in my mind than going to, the trial courts here in California. Although the trial courts, you have to be formal too, but it's a whole different set of circumstances. But I did find it funny that he was telling us how he was going to crush us and beat us down, and then he went and found the best appellate specialist that he could find to go against us.
That's like saying, I'm going to beat you up, and then you go get your big friend to do the job.
Yeah.
I thought you were going to, there's another story we had against a big firm where we won an appeal. I would have rather you told that story. But either way, you make a good point.
Well, it's good to be humble. It's good to remember the
It's
losses.
good to be humble.
Yeah.
Yeah. When you're a gladiator, you're going to lose some.
That's
and,
true.
You try to win most of them.
Yeah, that's true.
So anyway, those are our thoughts on the appeal. Anything else on the Vanderpump Rules front?
Well, maybe we can say it right. What is it, Vanderpump, or is it Prump?
Vanderpump Rules.
I don't know anything about this stuff, so.
I don't either. I'm doing the best I can.
Yeah. So I read another article this week. Rachel Levis, we talked with Christy again about this. She has her own podcast called Rachel Goes Rogue, kind of, talking about her truth and everything that's been happening to her. This week, she had on her own publicist, her own PR rep, again, talk about someone who's in your corner, getting your big friend to defend you. Her publicist came on to basically continue to bash Ariana, the other side in this, and say, even though Ariana is the one who was cheated on and lied to, she said, you could have handled this with grace, blah, 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 where shame, this ruined Rachel's life, things like that, where people are kind of seeing her as the villain, and in that way, she should kind of say less.
You know what this reminds me of a little bit, Erica, what you just said, and I don't know a lot about what you were just talking about. You listened to it, I didn't, but it's kind of like if you and I went to a bar tonight, we were drinking, and we had a few too many, and some guy walks up to me and he pulls out a little pocket knife, and he says, I'm going to get you. And I pull out 3 Uzis, and I just blow him away. Okay. He's dead on the floor, and the cops come, and I'm like, ha, self-defense. No, that's not self-defense. That's just overkill. It doesn't say that I have to pull out another pocket knife to match him equally, but I kind of feel like, yes, who was cheated on? Ariana? Is that who was cheated on here?
Correct.
Yeah.
Ariana has to feel, betrayed and all of those things. But when you come across something so incendiary as these videos, and I'm not saying she did disclose them. There's an argument that she did. That still has to be determined. But you can't take an Uzi out at a gunfight and blow somebody away. And that's what she ultimately had in her hands was an Uzi. And yeah, she had been wronged and she'd been cheated on, and all those things are horrible. But you have to meet force with force. And here, I just think it was a little bit overkill.
Well, and how many people even understand the legal consequences of sharing the video or not sharing the video? I mean, you see something like that and you're not a lawyer. You're probably just thinking, I'm going to show the world and expose you and show you the type of person you are, and all sorts of things, I'm sure, go through your head. But I don't think anybody in that case is winning awards for good behavior. And so everybody's got their side of the story. Everybody was damaged in a way, in different ways, maybe some more than others, maybe just, maybe unjust, but it just seems like there's a lot of damage to go around and a lot of blame to go around. But that's true in most cases. I mean, a lot of our legal cases, we'll represent one side and we're advocating for our side, but our clients don't understand that the other side, they feel just as convicted about their position as our clients feel about, our position. And they'll literally think, oh, the other side's getting one over on me. They're laughing at me. They know. And it's like, no, they're not. They actually think that you're taking from them. They actually think that you're getting one over on them. And when you try to explain that, and you've done that many times, Stewart, the client will say, how is that even possible? How is that possible? Well, because everybody's able to economize in their own mind why they're right and everybody else is wrong. So we see it all the time.
Well, and I think we had a client a few years back that would call us up and say, "What are we doing to?" Because they, basically saying that we were getting mopped on the floor by the other lawyers, and we're like, "Look, the case just started. There's a petition that's just been filed. Discovery can't even go out yet. We're going to get discovery going." But it was like, and that's an extreme example. But most clients don't understand how the other side, who they view as evil and liars and cheats and frauds, how it is that they can actually feel convicted that they're right. And the truth of the matter is that both sides in mediation feel that they're 100% right.
Yeah, 100%.
And it has to do with, I think, self-preservation. We, as human beings, think about the last fight you got into with your significant other, where you immediately said, "I'm wrong. I'm 100% wrong, and I'm sorry." That does happen from time to time, but most of the time,
it's pretty rare.
Yeah, you're thinking, "Wait a minute, I didn't do anything. Why are you mad at me?" And,
there's a lot of slamming doors and stomping around before you get to that point.
Yes,
in most situations. But yeah, it is interesting how people get entrenched in their position, and I don't blame them. I mean, anytime that we've been in a position where we've had to be a party to something, it does raises those emotions in myself, and so I don't blame clients for feeling that way, but it is interesting to have somebody come on with their own PR agent and talk about how great they are.
Yes.
Or aggrieved they are, whatever.
Yeah. Do you think that I've been wronged?
Yeah.
Yes, you have.
Yes.
Well, thank you, PR agent. Here's your paycheck for the week. Yes. Right.
Exactly. So, all right. Well, let's move on to our next topic. So we have kind of an update. We haven't talked about this before, the Reggie Bush lawsuit. So Reggie Bush, running back for USC, and of course played for your beloved
New Orleans Saints. Yeah.
Yeah. And he filed a lawsuit. This is September 23rd, suing the NCAA and USC for basically making tens of millions of dollars off of him and not giving him a penny.
Yeah.
And of course, the Big Five had a settlement recently where they agreed to pay something like $2.7 billion over the next 10 years. Although that settlement has not been approved by the court yet. But, I kind of don't blame him. I mean, he had his Heisman Trophy taken away for something that seemed really minor. And then they just recently gave it back. And they're negotiating. If you look at I looked at the complaint briefly, and they're talking about the kind of money that the TV rights alone were something like $80 million. And then they also had, let me show you this. They used Reggie Bush as the face of the video game for the NCAA football. I don't know if I can show that to the camera. It's probably not going to focus, but they're literally using his face on the video game. The video game makes $60 million, and Reggie Bush gets exactly zero.
Oh, Keith, actually, the year before it made 60 million. The year that Reggie Bush was on, it made 125 million. So over double with his likeness.
Well, his shares remain the same, no matter whether it was 60 million or 120 million, which seems to be zero. So what do you think about this, Stewart?
Well, I think that, I don't think it's right, but let me say Reggie Bush is doing fine financially. He did play for several big contracts in the NFL. And so he's doing fine. And the only reason I'm pointing that out, I don't think it's right. I think he deserves to be paid for the use of his image, his likeness, and so forth. But there's an even sadder story, and that's that of Johnny Manziel out of Texas A&M, who doesn't have a whole lot right now. He's pretty much lost everything from my understanding. He played for Texas A&M and literally brought in, over the 3 years that he started, $1 billion. They were able to build a brand new stadium, state of the art, and he received $0. They outsold, I forget his jersey number. I think it was number 2 or something like that. I forget how many jersey number they sold of his, and he received nothing. And so good for Reggie Bush. I hope he gets a bundle. There's a lot of money out there that could go to him, but I hope Johnny Manziel and a few of these other athletes that were left behind, I hope they get paid too. And I will say, I don't exactly like some of the stuff that's happening with these young student athletes where they're getting paid all these millions of dollars right now. But they are out there, they're playing. They're becoming famous for whatever reason. I think of the Colorado football team, Deion Sanders' team. Most of those guys, they have their own Instagram accounts. They go and DJ. They do all kinds of stuff, and they get paid lots of money. Now they can get paid for that. Before, the NCAA would penalize somebody or suspend them or not let them play football if they found out they were getting paid. So I think Reggie Bush wasn't there an issue too where he lost his Heisman over getting a very small amount of money?
Very minimal, yeah.
Yeah. So yeah, I hope good luck to Reggie Bush. I hope that he gets something out of this, and Johnny Manziel and a whole bunch of other people. I mean, quite frankly, if I'm Texas A&M and I'm USC, I'm stepping up to the plate right now, paying these guys something. So at least I don't look like, we took all this money and didn't give them anything.
Yeah, and it'd be fine if you didn't want to pay collegiate athletes, but the schools weren't making a bundle off of them if they weren't selling TV rights and all the other things. But because it's such a money-making venture, it's literally the NFL at the college level, maybe even more, I don't know.
Yeah.
And they're making a bundle off of these people. So if that's the case, then it seems like the athletes should be getting something out of that.
Right.
Considering that they're using their likeness and they're getting beat up. I mean, some of these people don't make it past college ball.
Most of them don't.
And, a lot of times it's because of injury or whatever. I mean, it seems like they should be getting something for the trouble.
Yeah, agreed, 100%.
Yeah, it really is a cash cow. I mean, these, teams have been such a cash cow for universities. And, it kind of, to a lesser extent, it's true of law schools and business schools that have been a huge cash cow to universities. And so what you've seen is the cost of like law school, for example, has hugely skyrocketed over the years, especially since the time that I went to law school and you went to law school. And it's beaten inflation, and it's gone up more than the regular tuition of the colleges because people will pay. And, it's just out of proportion to what you ultimately are going to make as a lawyer when you get out of law school, especially. But it's a cash cow. And so people, obviously are going to cash in on that. And to some extent, it makes sense. I guess it's what the market dictates. But on the other hand, it's a very uneven market. When you have students who want to get into school and they're getting federally backed loans, I mean, who's to say what that's worth?
Well, and that may be part of the problem is that because the loans are there and they're available, I think that juices up the cost of education. And I know that my son has started his freshman year this year at a big university, and I was a sticker shock for sure. I mean, I kind of thought what it would be, but it's not cheap. It's very expensive. To think that you're just going to get a college degree for, call it, $250,000, $300,000, whatever it is. And then law school, I came out of law school with about $225,000 in student loans. I was in the military, so I had the GI Bill for my undergrad, but then I had to pay for law school myself. And I remember thinking, oh, this is such a horrible thing. I have to pay these loans off. It took me about 10 years to pay them off out of law school. But now kids are coming out with double and triple that amount from law school. And they, that's like a huge mortgage. Good luck. You're going to get married. You want to buy a house. You want to have a kid. You're going to have to postpone some things so you can address your student loans.
Yeah, it's really outrageous. Between undergrad and law school, you're probably $400,000 to $500,000.
Easy.
I mean, in loans.
Yeah.
Insane. Just insane.
Yeah.
So, I mean, I don't have the answers, but I mean, that's clearly the problem, and it's unfortunate. So anyway, that's what we have on Reggie Bush. We'll keep an eye on that lawsuit as well, kind of see how that progresses. I think you had a question for us, Eric, about the Girardi case.
Yeah. I gathered some other questions around the web and from our followers. Here's a funny one that was posted on one of our videos, and simply put, how are all the Girardi and Key staff not jailed? So,
well, yeah, that's a little bit of an unfair statement just because there's a lot of people there. And we saw that in the trial, the Girardi trial. We saw the secretaries. I mean, they were doing the best they could. They're not lawyers. They don't know what's going on. They're doing what they're told. So when you say staff, in my mind, I'm thinking paralegals, secretaries, all the non-lawyer people. I think it'd be a little unfair to hold them culpable for what Girardi was doing. And I think the trial made pretty clear that Tom Girardi was the sole controller of that firm. Was that your understanding too, Stewart?
Yeah, and the same is true of our firm. Hopefully not what's happening at Girardi and Keese, but the same is true of our firm that, producer Eric, for example, he does not deal when money comes in for the clients into the trust account, and then we give the money to the clients. He doesn't work on that, doesn't know anything about it. And so if we were dirtbags and we were stealing money, which we're not, California State Bar, we're very ethical. Yes. We're not stealing any money.
No.
If we were doing that, we can't hold Eric accountable for that. I mean, he's a good guy and he comes to work every day and he works hard and he's just trying to, feed his family, his life, his dogs. He's got 2 wonderful dogs. He's got to feed them. They take a lot of time and effort. So don't hold him accountable for that.
Now, that might be true that some of the lawyers would be culpable, and there are a few of the lawyers who still are being criminally investigated. So that could be true depending on what involvement they had.
It's kind of unfair though, in my mind, again, without knowing more. You're working somewhere and you have a paycheck and you have a mortgage and you have student loans and you have all these expenses. You're just trying to make it. And when you see something, it doesn't smell quite right. What do? Do you quit and go and get another job? Now, if Tom Girardi comes to you and says, hey, let's steal some money together, yeah, you're probably gonna have to quit and move on. But if you're just seeing something that doesn't seem right, maybe you don't know enough about it. So again, I'd be very careful with holding these other people responsible unless they actually had their hands in the cookie jar and they were taking, money for themselves.
Well, we know Tom Girardi was never honest about what he's doing because per the trial testimony, he literally was lying to everybody.
Yeah.
So it'd be hard to imagine.
Yeah.
We are going to see the Chris Camone trial coming up in January, and then Girardi's sentencing should be set for December, or is set for December. So we'll kind of see how that shakes out. And based on that sentencing, the prosecutors in Chicago, I think it is, have said that they might drop those criminal charges and I think what they want to do is they want to see what sentence he gets here in California. And so if he gets enough of a sentence, they're probably going to drop the charges in Chicago and not go forward with charging him on those.
Well, I'm gonna go out on a limb and predict that he gets a life sentence.
Yeah, pretty much. Yeah, 5 years is a life sentence. At that age,
Yeah.
I think.
Yeah.
What's our next question, Eric?
Here's something else related back to Vanderpump and everything. Someone, I think this is a pretty easy answer here, but someone wondering about Ariana and Tom Sandoval's mortgage.
Well, I mean, I guess we'd have to know more about that. And that would be, is she on the loan? And if she's on the loan and he's on the loan, then I'm assuming they're joint and severally on the loan. They both have to pay it together. If one doesn't pay it, they can come out, the creditor can come after either one of them for it. But I'd have to know more about that.
Or they could foreclose on the house and then just hit her credit. But yeah, if she's on the loan, then she'd be responsible for making sure that's paid along with Sandoval. And what a horrible situation that would be.
Well, I mean, I think the same thing happened. We're going to move to another area here for a second with Ben Affleck and what's her name?
J-Lo?
Yeah, J-Lo. Thank you. How did I forget about J-Lo? They bought this. I think it was like a $50 million. Was it a $50 million house?
I don't know.
Yeah,
but yeah, that sounds right.
Now they're going through a divorce, and I mean, that's tough. I'm sure they have enough coin to carry whatever they need to on that, but it's just a very uncomfortable.
Well, I was just shocked because I thought for sure Ben and J-Lo would stick together this time.
True love.
Yeah.
The heart wants what the heart wants.
Yeah, no. Didn't work the first time. Let's try again.
12 bedrooms.
Oh, okay. 12 bedrooms?
Yeah.
How much is the house? Is it 48 million?
68.
60. I was only
okay.
off 20 million. So,
yeah, well, it's 12 million between friends.
Here's another question we saw on a video. This one talking about multiple beneficiaries, and someone had a question about a trustee and a bad trustee in that case.
Yeah. So you're a beneficiary
What's
of a
the question?
So you're a beneficiary of a trust, and the trustee ignored your disagreement and selling the house to a sister, who's probably also a beneficiary, at below fair market value, and then lied on the transfer deed that all beneficiaries agreed.
That's dirty.
Yeah, that is dirty. Yeah. And it's interesting because a trustee of a trust does have the power to sell assets in most cases. I mean, the trust could limit that, but it never does. And so the trustee can sell assets. And then when you tell people that, the next question is, but can they sell it below market value? No, they do have a fiduciary duty to treat the beneficiaries equally and to sell things in a way that would be in the best interest of the beneficiaries. That obviously means you must sell it at fair market value. So if it was a below market value to one of the beneficiaries and they tried to cover it up, that trustee has some problems.
Yeah, and that's different than a trustee selling it to a third party that they don't know. They call it arm's length transaction. If that were to occur, so even then, they better get an appraisal, and they better be within about 10% of that appraisal. So if they get 90% of that appraisal, they'll probably be okay. But really, what a trustee needs to do in a case like this, where they want to sell to another beneficiary, you got to go to the court and you got to file a petition and say, hey, I'd like to sell to this beneficiary. All the other beneficiaries are on board. Here are their consents and joinders. Can we get this done? And then a court can make a determination from there. That's the silver bullet. But here it sounds like there was a beneficiary that was being left out in the cold. And, one sister was selling to another sister at a pretty good reduced rate.
Yeah. And the good thing about going to court, you have to give notice to everybody. So if somebody does disagree, you can show up, you can object.
Right.
But yeah, it's funny how often these trustees who are family members, like children, think that they can do whatever they want to do. And they don't understand that that's not the way this works. You actually have a ton of duties that you have to live up to. So that would be a very big problem. That beneficiary probably needs to look into filing a petition to surcharge the trustee and hold her accountable for whatever the loss was.
Correct.
Here's another one. Here's the last one that I saw this week. It's probably a frequently asked question, and there's definitely a lot of documentation on our website. But if you guys can speak to this, how can someone find a copy of their parents' trust?
Yeah, not as easy as you might think. So trusts are private documents, so they're not recorded anywhere. So a lot of times people think, well, can I go to the county recorder? Nope, it won't be there. The trustee should have it. Who's the trustee? The parents, in theory, should have a copy somewhere around the house if you can get access to the house. The drafting attorney might have a copy, but then again, they might not because they're not obligated to keep a copy. So it can be a little bit of a pain to find a copy of a trust if you don't know where it's at. But typically, it's going to be, with the parents or with the trustee, whoever that is, and then you have to get it from them. And then if they refuse to give it to you, then you have to file a petition in court and ask the court to order them to hand it over. So what are your thoughts, Stewart?
Well, the way I understood the question was that the parents have passed away, and so we don't have the trust. And so how do we find it? Well, you start with probate code 16061.7, which is a requirement. Now, not everybody follows this, but it is a requirement that within 60 days of a trust becoming irrevocable, meaning it can't be changed anymore, or mom and dad passing away, and it becomes irrevocable by that very fact,
Right.
You have to provide it to two groups of people. And a lot of people miss this. It's not just the named beneficiaries of the trust, but it's all the blood heirs as well. So if all the blood heirs are out of the trust and they're not going to get anything, they still get a copy of it. Here's the issue. And we see this happen time and time again. The estate planning attorney and the trustee, who's being very paternalistic and doesn't like their siblings, will say, I'm only going to give you the operative instrument. So in other words, there was an original trust, there was 2 amendments, and then there's this restatement that came like a year ago. And the restatement kicks everybody out, but all the other instruments give everything equally to all the kids. So what happens is the trustee and their attorney, the estate planning attorney, they're trying to be cute. They just send out the last instrument, which is all the statute requires. And then what we do is when people come to us with that, we call up the estate planning attorney and we say, hey, dude, send us all the instruments. And when they give us the big middle finger, how easy is it to get those instruments?
Oh, we just file a lawsuit and we immediately do discovery. I mean, that's what's so frustrating about the code. And they did change the code recently just to solidify that you only have to give the current operative documents. Okay, great. What you've done by doing that is you've solidified that we're going to file a lot more lawsuits because in some cases, it's the only way we're going to get what we want, but we will get it. You're not going to stop us from getting it.
It's a lot like written discovery. We get people that propound written discovery to us, and we tell our clients, let's give them more than we should. Let's not give them attorney-client communications. Let's not give them work product, but let's just give them everything. Let them have everything. Don't hide. Don't redact stuff. When you redact stuff, you're just inviting a fight. So just give them everything. And a lot of times it's the cocaine on the coffee table. The police don't see it. If you put the cocaine in the closet, they see it. But if you put it right out on the coffee table, they just somehow overlook it. Well, if there's a bad fact, get them out there. You don't think those bad facts are going to come out at some point? Just get them out there and see what the other side does with them.
Yeah. Yeah, no, and I think that's true even of the earlier trust documents. Just provide them. I mean, because if you don't, then you're just inviting a lawsuit. And that's what we do. If we can't get them, we'll file the lawsuit. We'll get them. So yeah, just produce them. I mean, what's the harm? I mean, it is what it is at that point. And so the person who has to serve a copy of the trust under the probate code section is the trustee, right?
Correct.
And so if they don't do that, you can go to court and force them to do it. But when we say go to court, it's not the easiest thing in the world. There's not a pre-printed form for this. Like you have to actually draft up a petition, and that's usually done by a lawyer. but it can all be done.
It can all be done.
Yeah. So yeah, that's usually how we go about it. And it is confusing. It's too bad that there's not a better system. Really what the parents should do is give copies to the children, but usually they don't want the kids to know. Maybe they're doing something that they don't want the kids to know about. Oh, the worst is when they put it in a safe deposit box, because good luck opening a safe deposit box once mom and dad pass away. You got to go to court and get a court order.
That's right.
Usually.
Yeah, the banks are really difficult to work with.
Oh, I hate when they do that. Like, don't do that. Just, either keep it in a file in your desk at home, give copies to who the successor trustee is going to be, do something.
Yes.
But not a safe deposit box. Do you have any other questions?
That was it for this week that I gathered. Yeah.
All right. Excellent. Well, that's our update. Do you have anything else you want to talk about, Stewart?
I don't, but if anybody ever has any questions, feel free to ask them, and we'll give our best stab at answering them and getting you headed in the right direction.
Yeah, feel free to put questions in the comments below this video. We do look at the comments even after our lives are over and they're on YouTube. Also, we would like you to be sure to subscribe and hit the notification button so that you can know when we do go live. And if you have any questions, you can always reach out to our website, www. Do people say www anymore?
Well, you are. You're people. You are a people.
Anyway, it's aldavlaw.com that you can go to in our website. I'm still living in the 90s because I'm saying www.
Yes. It's the World Wide Web.
Yeah, right. Yeah, I'm still impressed by it.
What was the first website you ever went to? Very first one.
It's probably AOL or Yahoo.
Yahoo.
Probably Yahoo.
1995. My first website was Yahoo.
Yeah, that's
it had
right.
a bunch of hyperlinks,
Yes.
Yeah. I was like, this is so cool.
It was cool. Yeah. And it's only gotten better.
I think my first email I ever sent was probably around that same time, 1995.
That's back when emails were interesting, and now we just get flooded with junk.
Yes.
So anyway, thank you for joining us for another Ask Two Lawyers.
Who's the first president you remember? Never mind. All right. Never mind.
Taft.
Taft.
And we'll see you next Friday.
All right. See you next Friday.